Next case to be heard this morning is the State of Ohio versus Ryan Rader. Again, each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. For the appellant, again, if you wish to reserve that time, let me know when you come up to the podium, front podium. And
I'll get it right this time.
Great.
Again, I'm David Dowden on behalf of the appellant, Mr. Rader. In this case, it is another case where the facts themselves aren't that disputed. Clearly, this is a situation where Mr. Rader had a gun while intoxicated. In what he indicated, his roommate was shot. The question was this how did the shooting occur? Was it an intentional shooting, or did it result from the dropping of a gun? That was the issue of the case. Nothing else was really argued. One of the main issues here is the defense had argued that this was an accident. And the argument was that Mr. Rader had been in the room, and as he was walking out, he dropped the gun. In fact, Mr. Rader told the police that he had dropped the gun, and in dropping the gun, a bullet fired and tragically killed his roommate, Mr. Smith. The defense to that end brought in a couple of experts. One was a pathologist to counter the state pathologist argument that this was a close-range shot, and that the defense pathologist said, no, this was from a distance, and he explained why. He also brought in another expert who tested the Sig Sauer. The revolver was a Sig Sauer. I had 226R. And the argument from the defense was that this trigger pull was light. He had a friend that had come in and had gone to a practice round and had used his gun and actually said, look, this gun is dangerous. To Mr. Rader, it goes off quickly. And more importantly, brought in a ballistics person, Jason Thompson, who indicated that there had been a history with this particular gun that when it would drop, it could accidentally fire. The problem here was, in response to that, the prosecutor, in arguing, stood up and basically testified, through the question, but not much of one, and said, are you aware, where's the effect of, are you aware that we, indicating that the prosecutor who's standing there personally and somebody else, dropped this gun, dropped a Sig Sauer, not the gun, but dropped a Sig Sauer 14 times and it never went off once. There was no test. Defense objected, and the judge sustained it. The problem here is this is the classic, you can't unring the bell. It came out, probably the most damaging evidence to the defense case was the fact that this gun was tested. There was no testimony in court about anybody dropping a gun or how often it happened, in particular the gun, that the prosecutor basically told the jury, we did this 14 times, it never went off. It was the best way possible to impeach that particular ballistics person.
Counsel, I have two questions
Sure.
to ask you in that regard, just so I have an understanding here. I've read the briefs, but not
Sure.
the record yet. If you know, was trial counsel given any kind of report or discovery, either expert report or discovery, as to the gun having been dropped 14 times?
My answer, no.
No, you don't know, or no, they
No.
weren't?
I don't believe so.
Okay.
I don't believe so. I didn't see it, and I didn't see any reference to it. There was no expert called.
And that's my next question.
Yes.
Even on rebuttal after that statement, was the gun dropper called
The
in?
gun dropper was not called.
Thank you.
The prosecutor, and I understand this was said in frustration, I get that, but the prosecutor said, we don't know who else the we is. We don't know who it was. And so the problem is, I don't know how you possibly undo that, because you have the representative of the state who, the reality is, my belief is that they identify with the state, who is trying to do justice, who stands up and basically, this wasn't, a question of, sir, have you dropped the gun? In your testing, sir, did you drop the gun? Did you attempt to drop the gun? Which would have been fair questioning. He said, we dropped the time, objection, and then he continued and said 14 times, and are you aware it never went off? So he's asking the expert, if the expert was aware that the prosecutor had dropped the gun all these times. I don't know how you can get beyond that. That is one of those, we probably should have asked a mistrial at the time, because it was impossible for the defense to rebut this. How do you rebut this? They hadn't dropped the gun because it wasn't the gun. You know, I mean, testing other guns really doesn't do you a lot of good. It wasn't the gun involved. Had the state put on an expert and they filmed it and showed this particular gun and it dropped all, and that would have been fair. That's a fair for the, but that's not what happened in this case. To that end, the aspect in this case is the defense argued accident. Now again, the prosecutor in this case then brought up and said, sir, are you aware that if you're intoxicated and have a gun, that's a crime? It wasn't objected to by defense counsel. The argument of the prosecutor was accident requires that it be a legal action that you're doing, and the prosecutor's argument is that, if I understand it correctly, is that if you were drunk and had it, you were doing an illegal, so therefore it couldn't be, by law, it couldn't be an accident. Of course, then it brings out that he's doing an uncharged crime, and that's addressed in the briefs. What I would like to bring up, the problem is that all could have been avoided, that whole incident could have been avoided. Because what, if you look at this objectively, what happened here appears to be a reckless homicide. Clearly, being drunk, having a gun, earlier in the day he had pointed it at Emily Merkel, and after he had pointed it, he took the bullets out. She went crazy because she said, you pointed a loaded gun? Yeah, what's wrong with you? Reaction any of us would have had. At some point he must have loaded it again, and so even under the defense's position, you know, had he had an unloaded gun and he picks her up and puts her in the bed with Brandon, and somehow from whatever range, the door above, the gun goes off, it really is more consistent with the reckless homicide.
What is the culpable mental state for accident?
Accident, it has to be something, again, not during, I have the instruction in my brief, I apologize.
Would you agree with me there's not a culpable mental
No, there
state?
isn't.
Because it's an accident.
In fact,
Well, then how can you then, isn't that inconsistent?
yes.
Testifying accident?
Yes.
Are you saying they should have changed their whole
I'm
defense
saying
theory?
that if you looked at this, this was a reckless homicide because.
You're not getting my point. The defense was that this was an accident. How can you then ask for an instruction, recklessness?
Well,
There's a difference between I did it accidentally and I did it recklessly.
I guess that's the point. The point I'm trying to make, after the evidence came in and after what was said, that clearly this was more conducive to a reckless, I don't think that they would have been concluded. Let's say that the case is over, just as it came in. The defense says, Judge, we're not going to argue accident at this point, we're going to argue a reckless homicide. Because I think they get that instruction. I think that's a proper, I don't think they're bound, and if this is my mistake, I'm sure you'll tell me, but I don't think they're bound to, you can wait till the evidence comes in before you ask what instruction comes in. I can't tell you from this how many times, and for the prosecutor's point of view too, how many times the evidence comes in differently than what you believe is going to happen when you're selecting a jury and voir dire. And I don't think you're bound to what you believe the evidence will show, which is why the court says, I believe the evidence will show. If it comes in differently, you should ask instructions that conform to the evidence that came in, not what you believed it was going to be at the beginning of the trial. So I would disagree with the court that because in opening statement they said accident, that then based on the evidence, they're precluded from asking for something else. They're stuck with what they said, their theory at the beginning, at the end. And
If the evidence wasn't accident.
yes, exactly. And when
Okay, go ahead. I don't want to take up your time. Go on.
Sure.
I get your point.
okay. And so, and again, but the point is the prosecutor's point, I'm not sure I agree with how he did it, but the point is valid. The point is valid. The prosecutor's point being, look, how can you say this is an accident when you're drinking, you're putting bullets in the gun, you take them out, apparently put them back in again, you're carrying the gun while you're carrying, you know, that's a tough accident as opposed to a reckless one disregard for, you know, what may happen based upon your conduct.
Did your client testify?
Did not.
Okay, thank
He made statements to the police right away
That it was an
that it
accident.
was an accident. That's what he said, without question. But that's his view of things. But again, we've had a lot of clients who come in and say, this is what I think the law is, and I can't tell you how many times, no, that's not the law, this is what the law does. And that's incumbent on the lawyer to do so. Actually, that's my argument, but I think that the rest of it is clear from the briefing of what it is. But in this case, I think that the error made here was not having an instruction that matched with the evidence that came in during trial. Thank you very much.
You have 5 minutes left for rebuttal.
May it please the court, my name is Natasha Herrera, and I represent the appellee of the state of Ohio in this matter. I guess first to address the reckless homicide instruction. Although reckless homicide obviously is a lesser included offense of murder, that's not always required to provide the jury with the lesser included instruction. Depends on the evidence that was presented and whether or not the evidence would fit a acquittal on the murder charge and then a conviction upon the reckless homicide charge. And here, as appellant's counsel has stated, the defense's whole argument in this trial was that this was an accident. Obviously, Mr. Rader, directly after the police arrived, was on audio stating, the gun accidentally fell, it accidentally went off. This was the whole theme of their defense here. And as Judge Callahan had stated, that is inconsistent with an instruction on reckless homicide because an accident is unintentional result of someone acting lawfully, whereas reckless homicide requires an actual culpable mental state of recklessness. Therefore, that would have been inconsistent with the entire defense that they were presenting on behalf of Mr. Rader. Therefore, it cannot be said that his trial counsel was ineffective for failing to request that particular instruction in this case. And with regard to the questions about his intoxication at the time and whether or not that was a crime, during cross-examination of Sergeant Collins, the defense counsel had elicited testimony that, in fact, Ms. Markle believed the shooting was an accident initially, bringing into, obviously, an accident needing to be coming from some sort of lawful activity, and that's why the state then presented some questions with regard to whether or not an intoxicated person could actually have a gun, and obviously that being a crime would therefore then weigh against it being an accident that Mr. Rader had the gun and it accidentally fell and accidentally went off. Then next, with regard to testimony of other acts by Ms. Markle in a BB gun incident, that was next argument within the brief. Again, objections with regard to a trial is a trial tactic, which should not support a finding of ineffective assistance of counsel and should be granted deference. And here, that particular testimony was in fact admissible under 294559 and 404B with regard to showing that Rader's actions were not an accident or a mistake. And lastly, with regard to the last argument in the ineffective assistance of counsel portion of the brief, there was an argument with regard to the trial counsel failing to make an objection under 403A. And that is definitely, again, a trial tactical decision that should be granted deference, and any argument with regard to a 403A issue with regard to ineffective assistance of counsel is speculative at best, because that would require a speculation as to whether or not the trial court would have actually found that the evidence was substantially outweighed by a danger of unfair prejudice. And finally, with regard to the ineffective assistance of counsel claim, even if it was to assume that some or any of these actions were in fact ineffective, Mr. Rader was still required to show that there was prejudice as a result. And it must be viewed in context of all the evidence that was presented at trial. Here you had Ms. Markle's testimony, who was there obviously firsthand, stated that her and Brandon were laying in bed, that Mr. Rader had left the room, then came back in, had made a statement to the fact of, yes, just lie there, and after that, she heard a loud sound, popped up out of bed, realized that Brandon actually had been shot. He was bleeding from his temple. You also had the testimony of the state's medical examiner, who indicated that based upon the dense amount of stippling around the wound, the gun particles that were actually embedded within the wound, and the burning around the wound, that the shot was actually more than 1 inch, but less than 6 inches away from Brandon's head at the time the shot was fired. And that directly negates Rader's statements after the fact that he was actually in the doorway at the time that the gun fell and fired accidentally.
The counsel, the Trumbull County, I think it was Trumbull, coroner testified contrary to that, correct?
Correct, Your Honor. He did testify contrary to that, but he also did admit that he didn't have all of the reports, all of the evidence that was available to the coroner who actually conducted the autopsy in this case.
Well, could the jury's decision to believe the state's coroner versus the defense be based on that, or the fact that there was testimony by the prosecutor that the gun had been dropped 14 times without going off? Guess what I'm saying is I would really like you to address that.
Okay, yes, I can
Thank
move
you.
on to the second assignment of interrogation, Your Honor.
I don't want you to run out of time.
No, not a problem, Your Honor. And it must be, yes, the trial court did sustain that particular question from the state at that time. But it must be viewed in context of the entirety of the trial and all of the evidence that was presented. Here you had the state's own expert, firearms expert, who testified that he actually did in fact inspect the gun that was used in this case, found it to be functioning, found it to be having no issues, not broken or anything, was able to testify to all of the safety mechanisms that were actually contained within that particular gun that would negate it just falling from a short distance and accidentally firing. As well as, the defense firearms expert that they presented stated he didn't have any sort of 6-hour certification, which was the gun that was used here. He never actually inspected the gun that was used here. The testing that he did was just with regard to distance of the gun from the paper that he did and all of that. And he did make some admissions on cross-examination that he was unaware of these other tests that were done in California with the gun being dropped from an airplane and never misfiring. And that he also agreed with some of the statements with regard to the safety mechanisms that were in the 6-hour gun, and it requiring a significant amount of force for it to be able to go off just from falling. And he was also asked during his testimony to, hey, here's the gun, can you make this go off? Show us how that would happen, and what would be the mechanism of how that would be able to, fall and go off without accidentally, and he was unable to do any of that while they're sitting in the testifying. So in viewing all of the evidence that was presented in comparison to the one statement made by the prosecution, it cannot be said that that overcomes all of the evidence that was presented here in this matter. And just to briefly touch upon the last assignment of error in the jury instruction, there again must be viewed for an abuse of discretion. Here, the defense counsel requested in the actual accident instruction that there be some sort of statement that Mr. Rader was not required, did not have any sort of burden of proof with regard to proving the accident, that it was an accident, which was denied. However, the trial court did in fact instruct that it was the state's burden in order to prove every single element of each offense. And if it was the state failed at all, that, you know, obviously Mr. Rader would have been found innocent, or not guilty, shall I say. And the trial court also provided an accident instruction within for sure, within the first, charge, and did provide that to the jury, indicating that an accident, you know, this has been Mr. Rader's claiming that this is an accident, and did provide information with regard to that. At no point in time did the trial court nor any party ever indicate that Mr. Rader had any type of burden to prove that it was an accident at all. And also there was a question as to whether or not there was the accident instruction was close enough in time to the burden instruction, the state's burden. However, the state was unable to find any type of case law that would support that they had to be in some sort of closeness in time with regard to the two being provided to the jury. And therefore, the state would argue that the trial court didn't abuse its discretion with regard to the jury instructions, and would request that this honorable court uphold the findings of the jury and uphold Mr. Rader's conviction. Thank you.
Thank you. Right now, we have 4 minutes and 54 seconds.
Thank you very much. I want to address, just to make a point, that the issue about the BB gun. So it came out that, you know, she had been, Ms. Mark was shot by the defendant with a BB gun. And the prosecutor's response to that was it's trial tactic. Here's a problem with this argument. In any case, whatever the defense does is a trial tactic, but that's not the standard. It has to be a trial tactic within the professional norm. How do we determine the professional norm? Well, what would possibly be it has to be a reasonable trial tactic. It's not just a trial tactic, it has to be a reasonable trial tactic. What would be the advantage to the defense to allow in that the defendant who's charged with an improper shooting had improperly or accidentally or recklessly shot someone previously, having nothing to do with the date? I see none. I can't see any advantage to the defense for this to bring out, so that it wasn't a reasonable tactic within the professional norm. And so in reviewing what tactics are, it has to be reasonable, it has to be within the professional norm, not just that it was a tactic, because indeed every decision you make is a tactic. What happened in this case is that Mr. Rader, when first came to police, he was still drinking. Of course he said it was an accident. It would be surprising if he said anything else. He's not schooled in the law. He didn't mean for it to happen. To a lay person, if someone is shot and you didn't intend on shooting him, you're going to say it's an accident. He's not going to say, you know what, I think this was a reckless homicide because I was indifferent to what could have happened had I been carrying a gun and it went off. The problem is that the defense counsel formed his entire case to the fact that it's an accident, and the prosecutor, in many ways, they're right. It's difficult to say accident in this case based on the overall. So that he didn't base his defense on what the evidence actually showed. The standard for lesser included is in a light most favorable to the defense. It's not its sufficiency, it's a light most favorable to the defense.
And you know what, I get what you're saying, I really do, and it's difficult, but I guess the problem is, what we're really saying is, it was not reasonable for the attorney to go forward with the case with an accident defense, period.
In essence, yes.
you know, and what you're saying is he made a mistake because he should have either pled him out or said this isn't an accident, it's a reckless homicide. And that's a hard road to hoe for a defense attorney, isn't it? To say, you know, we're not gonna try to get you off on accident, we're gonna try to get you convicted of something else.
But, I mean, somewhat, I understand your point, and I want to address it, but I don't know what was offered. I mean, if they're not offered anything.
Well, I understand
So,
that,
but yes.
in reality,
But
that's what we're talking about.
But that's our job.
I understand.
It is
but-
difficult.
But it's, you know, it has to be reasonable, like you said, but it's also armchair quarterbacking too. And then you're taking the decision, it's very difficult for a court to say, you messed up, you shouldn't have tried to get him acquitted, period. You should have just tried to keep him in jail for a while.
And here's where I disagree with you.
No, go ahead.
I agree with you up to a point, but here's where I disagree. Up until trial, opening statement, even through the trial, absolutely right, nothing wrong with arguing accident. Totally agree. However, when all the evidence has come in, when you've heard what was said, you've heard the prosecutor's response, then it is your obligation to ask for instructions based on the evidence that's there, not what you knew before trial, that gives your client the best chance. And again, it's not even strategy, it's what the evidence showed here. Because I think,
How does trial counsel argue that switch in final argument and maintain any credibility for
well,
his
here's how.
client?
You stand up and.
Please tell me.
You know, sure. He said it's an accident. He said it's an accident because he believes it was an accident. Ladies and gentlemen, accident and the law are two different things. What he believes is an accident in the law can be this. Listen to the instruction. And does it form? So I don't think you lose your credibility doing that. I think you actually gain credibility doing that.
Until the state rebuts and says, see, they're just picking and choosing, and their accident evidence against their accident was so bad, now they had to switch to something else.
Oh,
I digress, I'm sorry. I get your point.
Okay, all right. Now, we can talk about that for a long time, but I
Yes,
see I'm
we
out of time, and thank you very much for your time.
Thank you.
Thank you. And thank you for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted to our website and that of the Supreme Court.